It's been a fascinating last couple of weeks here, thanks to this case that it depending on who you ask, was a completely novel, nearly case of first impression, but not we don't need to go that far. Interestingly, there was a motion in limine in the trial about where the SEC argued that the defense was not allowed to say that this was novel or first of its kind or some sort of new thing. Because the SEC's stance on this whole thing is this is a straight down the line misappropriation case. So, for those of you guys that don't recall, this was a case where Matthew Panuwat works for Medivation. Medivation gets a bid from Pfizer to be taken over. Obviously, Matthew knows that because he works for Medivation, but he ends up trading in a different company called Insight based on that information. And they're realizing that how Medivation's progress or how their share value would increase or decrease based on that information. That also might be the same case for Insight. So it's a peer type firm. Hence, that's why it's called shadow trading. So Matthew is convicted of insider trading. And so, interestingly, I think there are a few takeaways here. First, of course, this is going to be appealed. This seems to be something, obviously, that this person took all the way to trial. There's no settling before this. And I think we'll see an appeal based on this jury conviction. And I think we'll have it on a few angles. I think we'll see an appeal. I don't know if they can appeal this idea that they were not allowed to say that this was an unusual, new, unanticipated type of case. I think that might have fallen away to some extent, but there's, I think, real traction on there being an appeal based on the jury instructions in this case, because I think there is a little bit here to suggest that might have some legs on his argument about what the jury instructions said. And we see this all the time. The wording of jury instructions can make or break certain things. So Panama wanted the jury instructions to state that he knowingly breached a fiduciary duty owed to Medivation. That is pretty straight down the line what the requirement is in insider trading, but the SEC wanted it diluted a little bit to just be that Medivation entrusted Panuwat with confidential information and that he basically hadn't gotten their consent to trade on that information, even in Insight stock. So, like I said, fiduciary duty of trust and confidence, we're quibbling over the same thing, but those are the kind of things that can really make a big difference. And as we know, insider trading at this point is entirely common law driven. Nothing in the statute says any of these things. So every one of these is just building on previous case law, which is why each sort of nuance in facts or nuance in jury instructions start to have major consequences. Panuwat also was challenging how the materiality, basically, that it was this idea that this information about Medivation actually mattered to Insight. He really did take on this idea that Insight and Medivation aren't as one-to-one peer-linked firms as the SEC had suggested, that they weren't necessarily competitors, that there isn't necessarily a link that one of these companies' successes translates to the other's success. So he was trying to separate and really exacerbate the distance between these two companies. And that in itself is maybe you need some economic experts or however, I think that really is the nugget of this case that everyone had a problem with, which is how much are these things literally, are they not literally, but how linked are they such that this inside information about Medivation can equally apply to other firms. In that case, like I said, it's not over. I imagine we'll see an appeal up to the Ninth Circuit on this. Where it goes going forward is, as I said, I think in the last panel, maybe 10b5-1 plans or at least restricted tradings for employees needs to be tightened up a little bit just because employees could be exposed to insider trading liability if they are rightfully following even maybe a narrower insider trading policy that says I won't trade on this information in the shares of this company. But that needs to be brought into, and also these 10, 15, name it, sort of other companies that would be seen as economically linked such that this would be shadow trading. And so the paper I had posited this idea of 10b5-1 plans maybe need to include all of your peer companies. That sort of same idea of this is now going to be what you're prescribed from doing if you have any information here. We'll see. I think it's like I said in the last time, I think the reason I didn't think this was going to be going in Panuwat's favor is because of that employment agreement he had signed. So there's proof that he did breach and he did something wrong. He's trading in this. The question is his trading in Insight the equivalent of breaching an employment agreement? And in this case, it was because it was a really broad insider trading policy. It said I wouldn't trade in any other company. So I think on that alone, these particular facts make this case maybe a little more open shut. But if you had a different insider trading policy or not an insider trading policy at the company, maybe this goes a little bit of a different way. So who knows? I think keep watching this space.
Matt, do you have a question or comment for Karen?
I suppose a comment, although if it leads you to a question, I'd love to hear your answer, Karen. But I keep coming back to, aside from the legal complexities here, which you do an excellent job of laying them out, like there is still a real ethical risk in allowing this sort of thing to happen. In my non-lawyer perspective, I look at it as that Mr. Panuwat had material, non-public information that he traded, that he exploited for financial gain. And that's it. I, as a random investor, I did not have access to that information. And there wasn't really any way that you could figure this out or derive the right conclusion that you too, mere investor on the street, could also have the same lucrative investing opportunities that he did. And my fear would be that if for some reason this was allowed to stand, it really just smacks of that guy had some inside info and then he used it to fight for financial gain that the other people in the company, the mere mortals, the regular employees, we don't have access to that. It sets up this undeserved privilege. And as soon as you create that dynamic, your whole corporate culture and control environment is at risk because
Mm.
most people would look at that and say, he gets to do that thing and I'm on the outside and he's on the inside. If he can do that, that means morally, I guess I'm okay to be able to do these other things that only I can do. And some people might say that's cheating, but that's them on their outside while I'm here on my inside. And it's a it is an unfortunate slippery slope. So I thought he would wind up convicted. I hope this conviction stands. I can appreciate there's a lot of legal and policy nuance here that needs to be refined. But if you clear all that away, there's a real cut and dried ethical issue here. That just doesn't pass the smell test. And that is what I think a lot of senior executives just keep in mind. Because if you let one thing stay, a whole lot of other stuff.
I
Mark,
think
do you have a question or
yeah.
comment?
I had a question for Professor Woody, and that is, would it have been a little bit different, maybe, possibly, if he wasn't the head of business development? And then I have a comment, which may turn into a question or some commentary. And that is, I think this is a great reminder that from a lessons learned perspective, that when you're doing training and you're onboarding someone and you give them your insider trading policy and they sign off on it, or they sign off on an employment agreement, it can't be a set it and forget it exercise. These things need to be monitored. Those things need to be brought up on a regular and ongoing basis. And then lastly, when it comes to business development, any type of business development where you're dealing with this sensitive information, there needs to be controls around that. There just does. And there needs to be someone who is really overseeing this, maybe at the board level or the audit committee or somebody from there, because I've been involved in many mergers, acquisitions or whatnot, where there's been this, okay, we can't say anything because of all of these things that we're talking about now. And I can guarantee you this. I'm sitting in a cafeteria at one of the companies, I'm not going to name one, and all of a sudden I hear two people talking about like, how the heck do they know? There's no way that they could know what's going on, but nobody today can keep a secret. And so it's like kind of one of those things, but it has to be monitored and it has to be controlled.
I do think the fact that he was in the catbird seat there as business development is a fact that didn't help him at all. I don't know how much that would be legally significant because, as you say, you could kind of learn this in some other way, just any sort of insider motivation. He had certainly access to that. One of his defenses was an attempt to say this wasn't everyone knew that there had been some suitors for Medivation and also even for Insight. He pushed back on this being effectively non-public. I guess materiality and non-publics run together in this defense of his, which is this is something anyone could have probably surmised or sussed out in some way. And so I don't know. He was trying to take on every element that he could of whether this was material non-public information. But I take your point of I think this is gonna have to result in some tighter controls, much clearer controls about what is allowed and not allowed. I think his argument is, how different is this than that? I do think the fact that to the point of he was the business development person at Medivation, but imagine you're just driving by, you see a bunch of Pfizer trucks outside Medivation, and then you keep driving and you think, oh, that's interesting. I wonder what's happening there. Can you piece these things together? That's actually the whole problem with some of insider trading. That some insider trading is completely legitimate, even though it feels wrong. Like to Matt's point, I think the problem with insider trading is that it all intuitively feels like an opposite of what we want. We want it to be always an even playing field. And I think the trickiness with it is that it never will be. There always will be someone who has a little bit, just knows something else that maybe someone else doesn't. But I take it. I think this was one that will be tricky to overturn on appeal, certainly.
It goes back to the old cookie example that I always give when I teach my ethics class. And that is, I don't know if you remember when you used to check into a hotel room and it'd be 11 o'clock at night and you'd be traveling 14 hours a day because your flights were canceled. And the only thing left there was a thing of Pringles and a thing of cookies. And if you took it off, you got billed for it, right? But then you went down into the gift shop later and that same $9 bag of cookies was $2. So you bought the $2 bag and you put it back on the plate in your room and you're like, oh, I never ate the cookies.
I've
Well,
never done this, Jonathan.
well, guess what? It happens all the time. And it's ethics, really. What is it? It's really, it goes back to character and morals, right? And it's what you really do or don't do when nobody's watching. And that's, I think, fundamentally, Matt, you brought up a point that from an ethical perspective. He should have known to stay the frick away from this, and he didn't.
Karen, let me go in a little bit different direction because I had thought you had to pair material non-public information with a fiduciary duty not to use that information. And if someone was able to suss out, excuse me, yeah, someone was able to suss out information, it obviously was not non-public because they were able to figure it out, whether they drove past and saw a bunch of Pfizer trucks or whether they were the best AI/Google/internet researcher ever. Point one. Point two, though, is am I now, do I now have a fiduciary duty with all competitors of the Compliance Podcast Network that I can no longer trade in their stocks because I am an industry expert? And can you assume a fiduciary duty to a third party who is not a signatory to a contract where you've made that agreement? Can a third party be a beneficiary of being claimed that I now have a fiduciary duty to a third party? And I guess that's the point I'm stuck on.
Yeah. So the answer is yes, it can be a beneficiary, but the duty doesn't run to that third party. So the breach of duty was him to Medivation. And he wants that to be a much sort of more robust fiduciary duty of care, that kind of idea. Whereas the SEC wants it a little watered down. This was entrusted into you. This was this presumption of confidentiality in this exchange, which you do see written into 10b-5-2, which we got, which is after. This is the kind of stuff over the Mark Cuban case of just this. If we have an agreement that this is going to be held in confidence, then breaching that agreement is enough for misappropriation theory. And that goes to the source of the information, not to who you ultimately trade in. And that was the expansion from misappropriation theory that was different than classical insider trading, which is just, I know this because I'm in this company. I now can't trade in this particular company only. That's how those who wanted to cap in insider trading to a much more narrow frame wanted it just at that. When you start trading in other things that you have no relationship to, certainly no fiduciary duty to, everyone wanted that to be tossed. That were like the more conservative court of keeping this aside. But since the O'Hagan case, the Ginsburg wrote, we now have blessed misappropriation theory, which is even if there is a beneficiary, if that's insider or whomever, the other thing you're trading in, the duty doesn't run there. The duty runs to how you learn the information. So if you've gotten information through some type of breach of duty, or I guess I should say also, if there was supposed to be a duty of confidence to that source of information, and then you break it and go trade on it, then that's enough. So I don't know if
Are
that
you,
answers the question.
are you talking about access to the data, the material non-public data? Is that what you're saying?
Yes. So he was supposed to keep that in confidence and not use it. So trading on it is the breach. And the breach actually is between him and his employer. It's almost this idea that the information it belongs to Medivation. It's almost this idea of like, It's almost like a trade secret kind of thing. You've now breached a duty to Medivation in this promise to not use that information for your own gain. So
Let me ask you,
insight is just a
if he
third
lost $2
party.
million, were you talking about this?
If you lost money on it,
Yeah.
there's actually a really recent article that was interesting about this because I think the answer is that's crazy. That's not very good inside information if you didn't make any money on it. But this woman actually at Michigan, the business school in Michigan, wrote about how there can be advantage to that. Like you want to dump, if you have some tax benefit, there's some reason you want to take an L, take the loss on something. That could maybe still be problematic. It technically is by the letter of the law. You're trading on inside information, but the fact that it went the other way, I don't know. It's an interesting article, but that's a new theory.